particular reference. It has been found that reference in the arbitration agreement to any dispute to be settled by arbitration is sufficiently wide in terms of its wording to cover both contractual, i.e. restrictive agreements and practices, and tortious claims, i.e. abuse of dominance, for example. Now, the issue of whether a particular competition law is actually applicable is, of course, a completely different question. That depends completely on the substantive threshold criteria of a particular competition law, of which we've heard before as well. So you need to test, of course, as an arbitrator, whether a de minimis rule applies and whether the particular impact on competition is so small that actually forget about it, no issue, or other threshold criteria which may play an important role need to be tested first before you can, of course, apply competition law. So the general applicability of particular competition law doesn't mean that in a particular case it does apply. Here we also need to mention one very important thing. The arbitration agreement per se must not induce the arbitrator to enforce a cartel. So if you have, for example, a classic cartel arbitration, like Kartellschiedsgerichtsbarkeit as existed in pre-Second World War Germany, that would be absolutely prohibited nowadays. I.e. an arbitrator enforcing a cartel or assisting in the enforcement of a cartel does run the risk of making himself complicit in a cartel infringement and actually liable under the relevant applicable competition laws before the competition regulators. In the EU, there's no doubt in my mind, an arbitrator enforcing a cartel in the EU qualifies as an undertaking under 101 TFEU and will be as liable as anybody else. So it needs to be very clear. An arbitrator is not allowed to enforce a cartel. End of the story. The scope of the arbitrator's jurisdiction. In ordinary antitrust arbitrations, an arbitrator can, of course, hear enforcement actions under Articles 101, 102 TFEU and or any corresponding domestic antitrust provisions. An arbitrator can hear the Euro and or antitrust defense in ongoing arbitrations. Let's say a claimant advances a claim saying, respondent did not comply with our agreement, is in breach. The respondent can legitimately raise an antitrust defense, saying, this agreement I cannot comply with because actually it's null and void ab initio. It's in breach of the applicable competition law provisions, let's say Article 101 TFEU. An arbitrator can hear follow-on damages actions as well on the basis of findings of infringement by competent antitrust regulators. And of course, an arbitrator can award civil law redress, including damages, specific performance, injunctive relief. In commitment arbitrations, what will the arbitrator do? He will determine whether the parties have complied with the underlying commitments in accordance with the regulatory objectives of the competent antitrust regulator, i.e. the regulatory objectives of the underlying commitment decision. And he will equally determine whether compliance with the commitments does not produce any anti-competitive effects. Because maybe the Commission actually got something wrong, and he now knows, or the market environment has changed in the meantime, and the arbitrator realizes, hang on, if we actually comply with the commitments now, it may actually be that produces an anti-competitive effect. Maybe I need to send back the commitment decision to the Commission and let the Commission look at it again against the background of the newly changed market environment. Now, the arbitrator's findings, what can the arbitrator find? Well, in ordinary antitrust arbitrations, the arbitrator can declare that an anti-competitive agreement, null and void, ab initio, under Article 101(2) of the TFEU or any other corresponding domestic antitrust provision. He can declare that an agreement does actually comply with the exemption criteria, the legal exception under 101(3) TFEU, or any other equivalent domestic competition provisions. He can declare that an agreement is block exempted. He can find an abuse of dominance, obviously, under the relevant applicable antitrust provisions. And he can award compensatory damages and other private law remedies, including all those a court could normally award in the same circumstances, excepting, again, criminal sanctions, obviously. In commitment arbitrations, well, the arbitrator can may declare that the parties have failed to comply with their underlying commitments and order specific performance. He can declare that the implementation agreement, which is normally the private instrument, the private law instrument by which the commitment decisions or commitments, underlying commitment decisions, are put into practice, obviously. The third-party beneficiary entering into contract with, for example, a merged entity in relation to access to a particular pipeline network, that would be the practical implementation of a commitment by the merged entity under a conditional merger clearance decision to provide access to third-party beneficiaries, for example. Now, the arbitrator can declare that that particular implementation agreement between the parties is defective and order variation, modification of that particular agreement, bring it into line with the underlying commitments. The arbitrator can also declare that the commitments actually prove ex post facto insufficient because there's been a change in market environment. So I need to refer the commitment decision, back to the Commission for reconsideration. The arbitrator can declare that the parties have actually properly complied with the underlying commitments and render an exculpatory award. The arbitrator can also declare that there's actually no implementation agreement. So the party entirely failed to implement the commitments in the first place. And then may order the parties to draft an appropriate implementation agreement, possibly with the arbitrator's assistance. And then, of course, the arbitrator can again award all sorts of civil law redress flowing from any of these declarations, including compensatory damages for past non-compliance as appropriate. Now, I mentioned at the very beginning that the antitrust regulator may have some sort of interest in the arbitration proceedings. Now, that's a very hotly debated topic. Arbitration specialists are falling out with each other over it. It's, again, discussed in greatest detail in the famous book. Well, it's not famous yet. Hopefully it will. Just to give you a general idea, one important point is that the arbitrator's competence is entirely confined to adjudicating the civil law consequences of any competition infringements. Whereas the antitrust regulators, for their part, preserve their regulatory functions, including in particular the prerogative to impose public law sanctions, such as, for example, imposition of fines, the withdrawal of a commitment decision, or the dismantling of an already consumed merger. Not for the arbitrator to do that. So in other words, the arbitrator's private law mandate complements the public administrative functions of the competent antitrust regulator. The other side of the coin is that difficult relationship between the arbitrator and the Commission, or the antitrust regulator more generally. It could be the FTC or the OFT or anybody else. So there is an issue as to the antitrust regulator's potential involvement as an amicus arbitri in antitrust arbitrations. Very cleverly adapted the concept of amicus curiae. Here we have an arbitrator, so arbitri. So, question as to whether the antitrust regulator is allowed to receive all written submissions to the arbitration tribunal, including procedural orders, or the awards, preliminary, interim, final award. The terms of reference, i.e. the actual mandate of the arbitrator, the procedural timetable. Is the antitrust regulator entitled to file amicus arbitri briefs at any stage during the proceedings to the arbitration tribunal? Is the antitrust regulator entitled to question the parties, witnesses and experts at a hearing? Question mark. Is the antitrust regulator permitted to provide relevant factual economic data in relation to market definition, for example, to the arbitration tribunal, to make their task a bit easier? I mean, if the EU Commission already, has made some investigation, they've got all the data on file, I mean, why not cooperate a bit? And remember, in commitment arbitrations, there's already a link between the parties involved, on the one hand, and the Commission. It's not like that the arbitrator, by contacting the Commission, is telling the Commission anything the Commission doesn't already know. They know everything already about the case, in any event, because it was the Commission taking the commitment decision with an incorporated arbitration commitment. They invited, essentially, the parties to resort to arbitration for the proper implementation of the commitment. And then the question as to whether there can be any binding interpretations of the commitments, for example, by the antitrust regulator on the arbitrator and the parties. Conclusion. Number one, increasing importance of arbitration as a private enforcement mechanism of antitrust claims. You hear me loud and clear. Number two, important for antitrust counsel and antitrust regulators to appreciate this, to take it in and to read the book. I think that closes my talk. And I know that Zoltan is very disappointed now, because I think he thought I was speaking to a congregation of arbitrators.
Next time we come back to Dubrovnik next year, and please then deliver that.
Okay, anyway, thank you very much indeed for your attention.
Thank you, Gordon. And thank you to all, because I think we heard a very lengthy but very, very useful and very comprehensive presentation.